Court calls the case Valley Ranch versus Kimberly. Is it Irizarry? Irizarry. I'm messing up everybody's name. It's okay. And also Evergreen Apartments versus Kayla Smith.
James Fink for the plaintiff.
Hello.
Hello.
What's your name?
Kayla Smith.
She's
And where are we on this case?
299871.
Say it again. 49
299871. Sorry.
29971.
Just
All
under
right.
3,000. She has been approved and has some assistance coming that will cover almost everything. So if we could either set it aside or do a judgment.
When did they say that they're going to get that? We don't know.
They said within 2 weeks. The only thing because I paid the amount for June. So the only thing that should be over what they said they're going to pay is the late fee. But I talked to Sydney in the office and she said that she could waive the late fees if
they can get that paid.
Yeah, after they pay it.
So when did you talk to them when they said 2 weeks?
It was last Friday. They said Hawk said that they were going to pay, and then DHS said they were going to pay $520 and Hawk was going to pay the rest. And they said give them 2 weeks for the payment.
And that was last week.
Yeah, I believe so.
So this would be 1 week. Here's what I'm going to do on this one. I'm going to adjourn this out to the 13th. Let's see if we can get it paid prior to a judgment entering. 2025 at 12 noon. Okay, let's see if the checks get there.
Okay.
How about that? All right.
Okay, thank
All
you.
right, take care.
One detail that is easy to overlook here is that Judge Simpson is deliberately avoiding entering a judgment when there is credible evidence that rental assistance may resolve the debt within a short period. Courts handling landlord-tenant matters often have to balance a landlord's contractual right to recover possession with a tenant's opportunity to secure verified assistance. Notice that the judge doesn't simply accept hopeful promises. He anchors his decision to a specific timeline and expects payment to materialize before taking the next legal step. The tenant also strengthens her credibility by explaining where the funding is expected to come from, and by identifying recent communication with both assistance agencies and the leasing office. Those specifics matter far more than vague assurances because they give the court something concrete to evaluate. Did you notice that neither side spent time arguing about liability? Instead, the discussion centered on timing and whether outside funding would realistically arrive before the court needed to act. That's often the real battleground in these hearings, and Judge Simpson's brief adjournment preserves both parties' positions while waiting for objective proof rather than speculation.
Evergreen Apartments versus John Hudson.
James Fink for the plaintiff.
No response. Raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, sir, I do.
Go ahead, sir.
Your Honor, this is an action for non-payment of rent. This defendant owes $1,128.93 in rent. The costs are $172 for a total of $1,393 possession only.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested. Writ issue in 10 days. Evergreen Apartments versus Nelsa Nieves-Montanez.
James Fink for the plaintiff.
Oh, she is. Nieves-Montanez.
I see her.
Here?
Yes. Hello.
Can you hear me?
Yes, we can hear you. If you can turn on the camera, that'd be great. Oh, there she is.
Goes.
Okay. All right. How much is owing on this?
Including costs is $5,488.17. She's eligible for Hawk, but she's got to pay the other $2,500 first, which was the $2,500 I think she said she was going to pay.
Yeah.
But didn't.
Did you get that paid?
No, I'm not going to be able to. My son broke his leg, and there's no way I'm going to be able to stay in his apartment and bring him up 3 flights of stairs. He's going to be out for at least a year with a bad leg.
Got it.
And he's
all right.
autistic.
And what was the total amount, Mr. Fink?
$5,488.17.
Got it. All right. That's regrettable to hear, but I'm going to find, after hearing, find no tribal issue. I'll issue a judgment for possession in that amount. with a writ to issue the 18th.
Thank you.
What does that mean, Your Honor?
What that means, I've issued a judgment. If this
Mhm.
amount's not paid by the 18th,
Mhm.
they can seek an order of eviction to have you removed from the premises.
Oh, okay.
Okay?
All righty.
All right. Thank you. Good luck to you.
You too. Bye-bye.
Sunco Hills versus Devonta Jackson.
James Fink for the plaintiff.
And also La China Williams.
You got it right.
I got it. I got it. I didn't mess it up, Miss Williams. Did I?
No, you didn't.
Okay, I'm gonna have to be honest. I don't know what I would have said, but my judicial coordinator was in my ear saying La China, La China. So I didn't mess it up. All right. I'd love to be able to take credit, but I can't. All right. Okay. What is plaintiff's claim in this case?
Including costs, $2,981.61.
All right, Ms. Williams, how are you guys going to get that paid?
Well, I heard from Hawk. Well, I had a caseworker named Caitlin. I only heard from her from the intake visit about seeing if I could get approved for the funds, but I haven't heard from her since then. And I've been emailing and calling, but I got nothing. And DHS denied my SCR twice.
Got it. So, Mr. Fink, you see anything regarding? We don't have Amy today, but
Just our notes just say that no one's heard anything since the last week of May. I think it was the 27th.
and ma'am, how often have you been trying to get through to them? They just can't.
I emailed Caitlin 4 times since the last week, and I called there 3 times. I called them today, and they said they would reach out to her, but I haven't heard anything.
They can't do this to people. Well, this number's not going to get any worse. I'm going to adjourn it out 1 week. Ma'am, you just keep trying,
Okay.
and let's see if we can get somebody to tell us yay or nay, and then we can
Right.
figure out where to go, right?
Okay. Okay.
June 13th, 2025 at 12 noon.
That's
Okay.
over the plaintiff's
Let's-
objection, Your Honor.
Pardon?
That's over the plaintiff's objection.
Of course it is.
Thank you, sir.
I'm going to do it anyway. Let's just see. She's trying, but people have to give people answers.
I understand.
All right. Thank you, Ms. Williams. Huron Vista versus Wilbur Burell.
James Fink.
Burrell? Not here. If you'd like to take a default, you may proceed.
Your Honor, this is one of the, actually, all 4 of these defendants have agreed to participate in that payment plan that I know the court's aware of for Huron Vista.
Yes.
Could I, how about if I take a default on the record and submit a COD or a judgment under the 7-day rule?
Okay. That's fine. That's fine.
And if we enter a judgment and he participates, then we'll set it aside.
Okay. Very good. So what are your proofs?
This defendant owes $1,347 in rent. The costs are $176 for a total of $1,523 possession only.
Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested with the writ issue in 10 days. Huron Vista versus Alicia Boore.
James Fink for the plaintiff.
Oh, she's here. Hello.
Hi, Alicia Boore.
Okay, she's here. Were you participating in the program there, or?
Yes, I do have a question. Maybe I need to talk to my leasing agent because the guidelines is saying that they'll give a 1-month forgiveness, and I didn't understand which month they were forgiving. Being that I'm paying June and Hawk is paying the back pay. I just wanted to know what they were, because it's very intense. Once you sign that paper, it's like very strict guidelines. So I want to make sure what they're actually waiving.
I can answer that, Your Honor.
Yes, sir.
They will waive up to 1 month's rent. So it would be the balance that's due after Hawk makes the payment and she makes her payment plan payment. She still has to pay June, July, in August on time, and well, she's probably still, so she's probably going to have to be, she'll pay June, she'll have to pay July and August on time. Whatever Hawk pays will get credited, and then up to 1 month can be waived if she complies with everything through those payments. If Hawk pays the entire balance, she doesn't get a credit, but she can have the balance wiped out up to that amount.
Yeah, that's why I was a little confused because they're taking care of, I just have to do my part for this month. They're doing their part. What are we waiving?
Yeah. Well,
Why am I doing this? I just don't want to set myself up for something.
no, I got you. I understand. I mean, there's not a lot of moving pieces, but you're just trying to make sure you do what you need to do.
Yeah,
Okay. Were you talking to the office about this?
I was, and there's a lead guy that's over in another area who handles everything. So I've been communicating with him. I don't want to,
Okay, let's do this. I don't want you to be confused about it. Let me adjourn it out 1 week, the 13th, 2025 at 12 noon. Give you an opportunity to talk with them more and clarify exactly what it is. How's that work?
Sounds great.
Your
Thank
Honor,
you.
could we would the court be willing to, with the information that has been provided, advise her of MCR 4.201J so that if she decides that she's comfortable and wants to sign the COD, she doesn't have to come back?
Okay, so that makes sense to you? If the paperwork gets signed, there are certain things I have to advise you on the record, or you have to be advised of before I can sign off on it.
Okay.
Right? So if you guys enter into an agreement, you sign off, you won't have to come back to court. And so I'm going to advise you of the rights under that right now.
Okay.
Okay? So, ma'am, you would have 3 business days from the date of my signing of the conditional order of dismissal, which it would be, to file a motion for the court to set that aside. All right? If for whatever reason there's some confusion, some misunderstanding as to what your legal rights are, or your belief that some right that you have you didn't assert, you'd have to file that motion within 3 business days of my signing. Doesn't mean that I would set it aside, but you'd have that opportunity to file that motion. You understand that, ma'am?
Yes.
All right, very good. All right, so then maybe we can then get it entered. You don't have to come back.
Okay. Sounds
Okay.
Thank
All
you.
righty. You take care. Have a great weekend.
You too.
Huron Vista versus Jacqueline Taylor.
Whatever
Good
the
afternoon. Good afternoon,
Oh,
Justin.
she's here. Jacqueline Taylor and Tania
Tanaya
Tolliver.
Tolliver.
Tania
Tanaya.
Tolliver.
Yes.
And who are you?
I'm Jacqueline Taylor. I'm the mother.
Okay. All right. And Mr. Fink, how much is owing on this?
Including costs, it's 2363.03, and they are eligible for the payment plan.
Okay. So, Ms. Taylor, were you going to participate in that program at Huron Vista?
Yes, sir. We was communicating this morning, me and Mr. David. We're having some kind of difficulties with my portion of the rent. Section 8 gave me a paper saying they changed it in April. They gave them a paper saying they were going to change it in July. So he's going to look into it. He told me he would get back with me, but we're having some type of communication, a difficult communication with that part of the deal.
Gotcha.
Yeah, I think we're going to move her from June, July, August to July, August, September. So if we could do the same thing, Your Honor, set it for the 16th, or 13th, and hopefully she won't need to come back. We'll get it signed and done this week.
All right. So, ma'am, I'm going to adjourn this out to the 13th at 12 noon.
Okay.
Okay?
Okay.
If you work out all of the paperwork and sign off on it, then you won't need to come back to court so that I can then enter it. But from the date that I enter it, you would have 3 business days to think about it. If you believe that there's some confusion, some legal right you didn't assert, or some mistake, or otherwise there's some confusion on your part, you would have those 3 business days to motion to this court to set it aside. That doesn't mean that I would, but you'd have those 3 business days to think about it, okay?
Okay. Thank you.
All right, thank you. Huron Vista versus Rodney Taylor.
James Fink for the plaintiff.
Rodney Taylor did not check in. So I guess if you'd like to take a default on this, you may, and then let it decide, or I'll receive a COD in lieu of the judgment.
That's exactly what we're hoping will happen, Your Honor. Mr. Taylor owes $2,612 in rent. The costs are $176 for a total possession only judgment of $27.88 even.
All right. Judgment to the plaintiff, that is by default for possession, redemption amount, in the amount requested with the writ issue 10 days.
Thank you.
Thank you. Who's this? Peninsular Place versus Rihanna Johnson.
James Fink for the plaintiff.
Hello.
Hello,
Your name?
Rihanna Johnson.
All right. And applied through Hawk, what is owing currently?
Including costs, $3,489.98.
How are we going to get this paid?
So, the last time we talked, I had told you that I was having communication issues, and then I told you I could pay $750 yesterday.
Yes.
But I just didn't know, like, I never like did none of this before, so I'm trying to figure out like what's the process of paying it. So that's the only reason why I haven't paid it yet. But I didn't get as much hours, so I only got 400 instead of 750.
Okay.
But I also did Wednesday. Kaylin, she emailed Peninsular Place and she asked them for some documents. And she said once they get the documents to her that they could go through with the process. And then they emailed her back and said that they'll probably contact her at the end of this week or the beginning of next week.
Gotcha. Okay. So here's what I'll do. It sounds to me like there are people that may be able to help you. I'll find no tribal issue after a hearing on this matter. I'll enter the judgment in the amount requested by the plaintiff. However, a writ would not issue until the 20th.
I should be able to, because I think that Hawk pays like at least $3,000. That should be already paid before then.
Right. If Hawk will pay it, you're going to be, and then you need the 500.
Yeah,
which,
that should be paid way before then.
Right. So hopefully, that's why I set it out this way. Hopefully everything will get paid up. Just need Hawk to do their part. Okay?
Yeah.
All right.
All right.
Thank you.
Appreciate it.
Yeah, that was Miss Johnson, correct?
Pardon?
That was Miss Johnson?
Yes, sir.
Thank you. Got a little confused with my paperwork.
Peninsula Place versus, is it Jacqueline Gardner?
I think she's on Zoom.
She is.
Hi,
Hello. What's your name?
Jacqueline Gardner.
All right. And where are we now with her case?
Her total is $2877.81.
All right. Ma'am, how are you intending on getting that paid?
$28.77.
2877.81, but this is that one. Yeah. Okay.
So it's not
Do you have an
2,477. I'm seeing like 3 different numbers, and I called them 2 hours ago, and they said that the 2,477 was accurate. Is that not what he see?
Mr. Fink?
Something?
She said that she called and said that it was 2,477.81. Was that right, ma'am?
Yeah.
And they said that it was right.
I show
And I got my ledger too. My ledger says that as well.
it's interesting, Your Honor, because I've got a ledger that shows she paid $400 yesterday by check, and that's what took her balance to $2877.
Got it. Okay.
You see both
So
400s.
they
You see the one from
credited-
last week too.
I did not hear her, Your Honor.
Go
Do
ahead.
you
I'm
see-
sorry, Miss Gardner.
Okay. Do you see both payments for the 400 from last week as well?
No, I see a payment of $440 in April on the 7th, and then $400 on 6/5. Did you make a second payment yesterday?
Yeah, I made 400 yesterday and 400 last week, and then I made 200 this morning.
Give me just one moment, Your Honor. I'll see what I can figure out. I don't have anything. If you want to pass it, I'll try to call them when we're done. Or if she paid it, she'll certainly get credit for it, Your Honor.
There's a
Right.
couple checks on there as well. When I called them, they said that ACH payments have been going through, and I'm assuming my family has been paying, and that's been also taking my balance down. That's on my ledger that's on my account online as well. They confirmed.
So they
That
said there's ACH payments that have not gone through?
they cleared. They got the money for them, but it's not deducting.
Okay. So, well, Ms. Gardner, are you going to continue to pay? I know this is a strange circumstance because
Yeah.
she would qualify for HAWK, but she's on pregnancy leave. And because she's on pregnancy leave, she doesn't qualify for HAWK. So, I mean,
Yeah.
and I know she
Yes,
said
I'm
the
gonna
last
continue to
time.
pay.
Pardon?
Yeah, I'm gonna continue to pay what I can through family, but yeah, the Hawk thing denied.
Why don't we just adjourn it a week, Your Honor?
Yeah, that's what I was going to do.
This exchange
13th.
highlights a problem that can dramatically affect eviction proceedings: disputed accounting records. Instead of arguing about whether rent should be paid, the conversation shifts to whether the landlord's ledger accurately reflects payments that the tenant claims have already cleared. From a legal standpoint, that distinction is critical because an inaccurate balance can influence both the amount owed and whether an eviction should proceed. Judge Simpson resists making an immediate ruling on conflicting financial information. Rather than forcing a decision based on incomplete records, he gives both sides time to reconcile the payment history. That approach protects the integrity of the process because eviction decisions should rest on verified evidence, not bookkeeping uncertainty. The tenant also gains credibility by providing a detailed payment history instead of making broad claims. She references multiple payments, family assistance, and conversations with management, while the plaintiff acknowledges that additional information may need to be verified. Those admissions reduce the likelihood that the dispute is simply an attempt to delay the case. If you were the judge, would you enter an eviction order while questions about the accounting were still unresolved? This moment shows why accurate financial documentation can become just as important as the lease itself.
June 13th, 2025 at 12 p.m.
Okay.
Okay? And then we'll try to get those payments cleared up. Keep paying. You and your family keep paying, and let's see what we can do with this, okay?
Okay, thank you.
Thank you, Ms. Gardner. Peninsula Place versus Carly Kenny.
James Fink for the plaintiff.
Carly Kenny did not check in. You may proceed.
Your Honor, this is an action for non-payment. The defendant owes $112 in rent, $250 in costs, for a total of $362. We request a default judgment for possession only in that amount. I'll add no writ without a hearing to line 10.
Thank you. Judgment to the plaintiff. That is by default for possession, redemption amount in the amount requested with the writ issued 10 days. No writ without a hearing. Thank you. Court calls case of Peninsula Place versus Amy. Is it Diagne? All right. Peninsula Place versus Crystal Okconor.
James Fink for the plaintiff.
Hi, Honor.
Hello. What's your name?
Crystal Okkonor.
All right. And what is plaintiff's claim in this case?
Ms. Okconor owes $3,099.88 in rent. The costs are $250 for a total of $3349.88.
All right.
Okay, so
Go ahead.
I know I was supposed to pay the 400, but I made a mistake and told you the wrong date. I do not get paid until the 11th.
Oh.
And I can make that 400 then. Washington mental health denied me, so I won't be able to get help from them. But I am trying to reach out to Friends Indeed, because I haven't been through them. So I'm trying to reach out to them, but they haven't answered the phone yet. So I'm working on that. And also, I'm trying to get another job. I went to a job interview yesterday, and I'm just waiting on them to give me the information to start the job.
Okay. Here's what I'm going to do. I'm going to grant a judgment for possession as well as a money judgment in the amount of the $3,349.88, finding no tribal issue after a hearing in this matter. Or maybe over plaintiff's objection. I'm going to give you to the 23rd to get that paid. So I'm going to give you about a week additional time to try to figure out how you're going to get this paid.
Okay.
Okay?
So that means I have to have the whole.
That whole amount by the 23rd.
Okay.
Okay?
Thank you.
Thank you. Private Asset Management versus Sandra Moore.
James Fink for the plaintiff.
The Haven versus Mary Heinman.
Fink for the
She
plaintiff.
is.
Hello.
Hello. What's your name?
Mary Heinman.
Okay. And let's see where we are in your case. What do you have her owing at this point?
Her total is $29.93.92, and I think she's going to have it all paid by the 18th.
Yeah, Puck said that they would be able to, they submitted the request and it was approved, and they said it would take 10 to 14 days to pay.
So Hawk is going to pay this? Is that what you have, Mr. Fink?
Let me just double check. I don't think I have how it's going to get paid, but that she's confident. Oh, she is. They say the check is in the mail.
Okay.
That's kind of what she was telling me. So Here's what I'm going to do. I'm not going to issue a judgment. Miss Hyman's been here and it looked very bleak for a while as to how this was going to get done, but she stood tall and did that. So I'm going to give her a break and I'm going to adjourn this. I don't have the 20th. I'm just going to adjourn it over plaintiff's objection out to the 27th, 2025 at 2 p.m. And if it's all paid, you don't have to come back. All right.
Not that I don't want to see you, but my work schedule, it's been stressful. So thank you.
Well, thank you for telling me it wasn't because of me. I do appreciate it. All right. You
Thank
take
you.
care. Have a great weekend.
You too. Thank you.
The Haven versus Whitney Albright.
James Fink for the plaintiff.
Hey there.
Hello. What's your name?
Whitney Albright.
All right. And what's the claim on this case?
2689.97, and she says she will have it paid by the 6th, or she says she'll have it paid by the 18th, and my client has agreed to extend the redemption period to that day.
All right. Is that correct, ma'am?
It is, yes.
All right.
I made my payment this week and I'll get paid in 2 weeks again and I'll make the rest.
All right. I'll find no tribal issue after a hearing. I'll issue a judgment for possession, 2689.97, with a writ to issue the 18th. All right. So get that paid and then you'll be all set.
Thank you. I appreciate it.
Thank you. You have a great weekend.
Thank you.
Is that it for you, Mr. Fink?
I believe it is, Your Honor. Thank you very much. Thanks for allowing me
All right.
to resume.
No problem. Have a great weekend, sir.
You also, sir.
Looking back across this docket, one consistent theme stands out. Judge Simpson treated each eviction case as an individual legal question rather than applying the same outcome to every tenant. When assistance programs appeared credible, payment records remained disputed, or negotiations were actively progressing, he frequently chose adjournments to allow those processes to play out. By contrast, when tenants failed to appear, could not establish a viable payment path, or no genuine factual dispute existed, he entered judgments for possession in accordance with the evidence presented. Another important lesson is that eviction hearings rarely revolve around emotion alone. Personal hardship, medical emergencies, pregnancy leave, or employment changes can provide context, but they do not automatically eliminate contractual obligations under a lease. The court still requires documentation, payment history, eligibility for assistance, and legally supported explanations before altering the normal course of the case. Equally noteworthy is the judge's effort to explain procedural rights whenever settlements or conditional dismissals were discussed. Those explanations help ensure that tenants understand the legal consequences of agreements before they become binding, reinforcing fairness and reducing the risk of misunderstandings later. What do you think was the biggest factor influencing today's outcomes? Timely documentation, consistent communication with assistance agencies, or simply appearing in court prepared to answer the judge's questions? Each case suggests that preparation often matters just as much as the financial hardship itself. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.